Good morning. This meeting is called to order. Mr. Troman, has anybody signed up for public comment? All right, a rare occurrence, but we do have something to reconsider on agenda item 3.
Yes, sir. Commission Appeals is requesting a letter of continuing jurisdiction in case number 3647740. Now, this case was on docket 52 on January 7th, 2025, and the commission voted to deem the claimant's petition to reopen timely and remand the case to the appeal tribunal. A decision was mailed the same day, January 7th, 2025. However, the decision erroneously ruled that the petition to reopen was not timely, while also purportedly remanding the case. The appeal deadline expired on January 21st, 2025, and there's no indication of an appeal, but the decision has not become final because it's void on its face. The decision is both contradictory as written and does not reflect the vote of the commission. Therefore, Commission Appeals is requesting to issue a letter of continuing jurisdiction so that a corrected decision can be mailed. Commissioner Trevino.
I agree.
Commissioner Esparza.
I agree.
And Mr. Chairman.
Agreed.
Thank you.
Moving on to agenda item 4. This will be tax liability cases. We do have one case on docket 11 and 2 cases on docket 12.
For the record, Hugh Daniel, Special Program Appeals. That is correct, Chairman Daniel. There is one tax liability case in docket 10 and 2 tax liability cases in docket 11. For docket 10, the case number is TD-24-065-1224. Commissioner Esparza.
Agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Chairman
I
Daniel.
agree with staff recommendation.
Thank you. For docket 11, the first case number is TD-24-055-1124. Commissioner Esparza.
The docket 11 or 12?
I'm sorry.
We got
Docket 12. One case on docket 11, 2 cases on docket 12. The first case on docket 12, I'll repeat the case number. Good catch. Thank you, Commissioner. The first case number on docket 12 is TD-24-055-1124. Commissioner Esparza.
agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Chairman Daniel.
Read that to me one more time.
It's 24-055-1124.
Agree with staff recommendation.
The second case number for docket 11 is TD-25-001-0125. Commissioner Esparza.
Okay. This is docket 12.
You're right. I'm
Correct.
sorry.
Okay.
Docket 12.
That's all right. Agree in part and disagree in part with the recommendation. I agree that the operators are not in employment. However, some of the plumbers, presumably the journeyman plumbers who have the most experience, have their own companies, hire and pay their own crews, and would appear to be employers in their own right. Additionally, additional analysis is needed for those workers. We need to find out which plumbers have their own companies, what the nature of those companies is, and whether any of them are registered with TWC as employers. Clearly, if they are hiring and paying their own helpers, they need to be registered with TWC, reporting wages and paying unemployment taxes. Once we have the information on which of the plumbers have their own companies and are conducting themselves as employers, we can reach a proper decision as to the employment status of the various workers involved.
Commissioner Trevino.
I agree with staff's recommendation.
Chairman Daniel.
So for the record, I think the journeyman plumbers are not in employment, but I'm going to concur with Commissioner Esparza so we can do a thorough job on this and we can reach some sort of conclusion today rather than arguing about it right here. So I'll concur with Commissioner Esparza.
All right, we'll rehear the case. I believe that's the vote. Rehear the case and resubmit the proposal after the rehearing. Okay. We have the majority vote on rehear and we'll resubmit the case for the future docket.
Correct. All right. There's no fair housing cases on agenda item 5. There's no child labor cases on agenda item 6. Under agenda item 7, we have one wage claim case on docket 11 and none on docket 12 that are pulled for additional discussion.
I'll make sure it's confirmed clearly on the record that that first case that we voted was docket 11.
That's the way I understood it.
Yes, ma'am.
All right.
11 and 12.
Thank you.
Thanks.
The case is case number 23-06-000-8. Commissioner Sparta.
The AT decision is not supportable based on the record currently available. The claimant's and employer's stories about whether the claimant worked for the company for any period of time are diametrically opposed. Although the claimant offered many screenshots of texts and emails allegedly sent between him and the employer flatly denies that any of them are real and that the claimant was ever associated with the company at all. The employer makes a very good point that the email address that the claimant used for communicating with the employer was completely fictitious, and that she never uses Gmail for email, does not spell her name in the way it appears in the claimant's screenshots, and that she has a perfectly good non-Gmail address at her own domain for any emails she sends. It is clear that either the claimant is lying or the employer and its witnesses are. Since the authenticity of the telephone numbers and email addresses is complicated and technical matter, we should instruct the Fraud Detection and Compliance Monitoring Division to investigate and report on the validity of each phone number and email address given by the parties, after which the case should be resubmitted with the FDCM report.
The decision is correct. Although the employer alleges that the claimant never worked for them, the claimant provided credible sworn testimony that he worked for the employer for about 4 weeks as a night security guard and provided a substantial amount of documentation to show this. Additionally, a TWC investigator previously spoke with one of the employer's witnesses who confirmed that the claimant had worked for the employer, but said that she did not want to get involved with the investigation because she feared losing her job. While this witness denied knowing the claimant at the hearing, she was contacted for the hearing at the same number the TWC investigator had previously called her at. Therefore, the weight of the credible evidence established that the claimant did work for the employer, but was not paid for 132 hours of work he performed. Affirmed that WCAT, employer correctly named, $2,772 in wages owed to the claimant.
I concur with Commissioner Esparza.
Thank you. We will send a memo to FedCom and resubmit the case. That was all of the pulled wage claim cases for dockets 11 and 12. You should have received the wage claim short form dissent lists for dockets 11 and 12.
I move we accept staff recommendations on the remaining wage claim cases on dockets 11 and 12.
I second the motion, except for those cases which I am dissenting as reflected on the wage claim short form dissent list for docket 11 and 12.
I concur with the chairman's motion, except for the cases on which I am dissenting is reflected in wage claim short form dissent lists for dockets 11 and 12.
Motion passes with the exceptions noted.
Thank you.
Let's move then to agenda item 8, consideration of unemployment insurance cases. Please proceed when you're ready.
Docket 11, first case is 2988632. Commissioner Esparza.
We should reverse the AT decision on good cause. The employer appealed the determination on April of 2021, but due to agency issues, the hearing was not scheduled until December of 2023, more than 2.5 years later. Based on this delay, the employer should be considered to have good cause and the case should be resubmitted for merits. But even if the employer did not have good cause, the employer should not be charged for benefits. The available record indicates that the claimant was discharged for being absent from his department for an extended period of time. According to the claimant, personal illness caused this absence. Under these circumstances, the claimant should be qualified for benefits and the employer's account should be protected from the charge under a medical separation analysis. Modify the AT decision. The employer did not have good cause for its non-appearance. No misconduct, no chargeback, NVI.
The AT decision is correct. Regarding the good cause issue, the employer received the hearing notice at their address of record, but their witness failed to appear for the hearing due to the employer's internal mishandling of the hearing notice. Since the employer was not prevented from participating in the hearing by circumstances beyond its control, the employer has not established good cause for its failure to appear at AT1. Regarding the job separation, though the claimant admitted to taking a longer than normal break due to a health issue, the available record did not establish that the claimant engaged in any actions that could be considered misconduct connected with the work. Affirm the AT, employer did not establish good cause for AT1, no misconduct, chargeback. In the alternative, since the claimant indicated that he took an extended break due to health issues, I could agree that the claimant was discharged due to a medically verifiable illness. Modify the AT, employer did not establish good cause for AT1, no misconduct, no chargeback, MVI.
No good cause, no misconduct, chargeback.
We do have a majority vote to pay and protect on MVI.
Short form dissent.
Yes, sir. Thank you.
Case number 32415543, Commissioner Trevino.
The AT decision is not supportable. The claimant showed up for the first AT hearing, but was told that it was just a preliminary hearing and that another hearing would have to be scheduled. The claimant informed the hearing officer that he was going to be out of the country for the next couple of months and requested that the hearing not be scheduled until after Thanksgiving. Despite this, the AT scheduled the next hearing on November 10th and issued a decision a few days later. By the time the claimant returned home and received notice that some of his mail had been held at the post office, including the AT1 decision, the appeal deadline had passed. Since the claimant's late appeal and non-appearance was caused by the AT scheduling the hearing while the claimant was out of the country, the petition to reopen should be deemed timely, good cause should be granted, and the case should be resubmitted for merits testimony from AT2. Reverse the AT, timely petition to reopen, claimant had good cause for AT1, resubmit.
The AT decision is not supportable. Normally, a party is responsible for making proper arrangements to have its mail checked and timely responses made to determination. However, in this case, the claimant had made a specific request during the first hearing to not have the next hearing within the next 2 months. Apparently, he was not told at the time that the appeal tribunal would not honor that request. It would have been both easily and proper to give the claimant a straight answer on that matter. Under these narrow circumstances, the lack of a direct answer to the claimant's request can be considered misleading information from TWC. Accordingly, we should hold the Rule 16 request timely and resubmit the case on the merits of the waiver issue.
Timely petition to reopen, good cause, resubmit.
Hold on. I'll agree with the rest of the commissioners.
Very well. We have a unanimous vote that the petition to reopen was timely, the claimant established good cause, and the case will be resubmitted. And just to clarify for the record, it's my understanding that your rationale, Commissioner Trevino, is TWC error in scheduling the hearing during a period when it was not requested or requested to not be scheduled.
I don't know if it would be considered an error, but that's fine. It was just didn't take the claimant's schedule into account.
Okay, and just want to verify there's a majority vote on that rationale.
Or I could say commission misinformation would be probably better.
Sorry, I just need to clarify the rationale. Yours was misinformation, sir?
Yeah, misleading information. Oh, I'm sorry. Yeah, I'd stated that the lack of a direct answer to the claimant's request can be considered misleading information from
Okay.
TWC.
Thank you. It appears we have a majority vote on misinformation.
I think.
Thank you very much.
Case number 3601277, Commissioner Trevino.
The deadline for the claimant's appeal to the commission was October 25th of 2023. The commission records show that the claimant's appeal, which was submitted through an online portal, was received on October 26, 2023 at 12 a.m. Since the claimant's appeal was dated just seconds after the end of the appeal deadline at 11:59 p.m., the appeal should be deemed timely and the case resubmitted for merits testimony. Deem the CA appeal timely, resubmit. In the alternative, this case should be reheard so that the claimant can be questioned regarding when his appeal was submitted. so that it can further determine whether that it was a delay in the electronic submission of the appeal. Rehear.
The claimant's CA appeal should be dismissed as late. In a second untimely appeal, the claimant acknowledged he had difficulty understanding the appeal process and experienced emotional distress. While I empathize with the claimant, there are no good cause exceptions to the timeliness rules. Accordingly, we should dismiss the claimant's CA appeal as late and leave the underlying AT decision in full force and effect. The claimant did not have good cause for his non-appearance, valid claim, misconduct, no chargeback, adequate employer response.
Deem commission appeal timely, resubmit.
We will resubmit the case.
Case number 3637568, Commissioner Trevino.
While the claimant filed a late appeal to the commission, the AT decision was returned to the TWC as undeliverable. Additionally, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there is no separation from employment and the continued claim should be voided. Deem the CA appeal timely, set aside the AT decision, void the continued claim.
The claimant's CA appeal should be dismissed as late. The claimant filed his appeal several days after the deadline. There are no good cause exception to the timeliness rules. We should therefore dismiss the claimant's CA appeal as late and leave the underlying AT decision in full force and effect, voluntary leaving, overpayment.
Deem commission appeal timely, resubmit.
We will resubmit the case. Let me just clarify. Actually, my notes are not showing a resubmit vote for you, Commissioner Trevino. You did vote for a timely commission appeal, but we don't have a majority vote yet on what to do with the merits after that.
I'll agree with Chair, resubmit.
Thank you. We'll resubmit the case. And one moment, please. I've been asked to clarify the vote for the very first case on docket 11, which is 2988632. My records or my notes here show that we have a majority vote for no good cause for the employer, claimant qualified, employer protected, MVI. I believe that was your second vote, Commissioner Trevino.
That is correct.
And that was also your second vote, Commissioner Esparza.
That's correct. No charge, no misconduct, no chargeback.
And then you short form dissented, Mr.
That
Chairman.
is correct.
Thank you very much, gentlemen.
Yes.
And continuing with the fifth case on docket 11.
Case number 3645960, Commissioner Trevino.
This case should be submitted for the rehearing. While I agree that the claimant's appeal should be deemed timely, the evidence suggests that the claimant's separation was caused, at least in part, by a family violence situation. The claimant was not questioned regarding this situation or whether she had the proper evidence required under Section 207.046 of the Act. Therefore, this case should be reheard to question the claimant regarding whether her separation was caused by family violence and whether she had any evidence required under the Act. Rehear.
We should reverse the AT decision on timeliness. The claimant provided only good cause reasons for filing a late appeal. Having a permanent mailing address is not required for receiving TWC determinations. The claimant could have elected to receive documents via electronic correspondence. As there's no good cause exception to the timeliness rules, we do not have jurisdiction to consider the underlying merits here. Modify the AT decision, late claimant appeal, misconduct, no chargeback, but even if the claimant's appeal is deemed timely, disqualification is still appropriate. Claimant was discharged for repeated tardiness after prior warnings. As such, she mismanaged her position of employment. Concerning the issue of family violence, because the claimant did not quit her job, section 207046 A2 of the Act does not apply. Affirm the AT decision, timely claimant appeal, misconduct, no chargeback.
Timely appeal, rehear for documentation of domestic violence under section 207.046.
Majority vote is the appeal is timely. We'll rehear the case.
Case number 3646220, Commissioner Esparza.
We should reverse the AT decision. The employer's claim response was late due to non-receipt of the notice of application for UI benefits. The employer provided her parents' address as the address of record and timely communicated with her parents about receipt of the claim. Her parents confirmed that they did not receive the notice in the mail. Since the employer's response was late due to non-receipt, we should reverse the AT decision, timely employer protest, resubmit for merits testimony.
The AT decision is correct. The employer filed a late protest to the notice of initial claim. Although the employer alleged that she did not receive the notice mailed to her on 8/10/23, she was using her parents' address for the business's mailing address and was not personally checking the mail sent there. Since the employer offered no firsthand testimony to rebut the presumption of receipt, there is no basis for deeming the employer's protest timely. Affirm the AT, late employer protest.
Timely protest.
The protest is timely by majority vote. We will resubmit the case.
Case number 3649929, Commissioner Esparza.
We should reverse the AT decision. The claimant was terminated for falsification of company time. Although the employer authorized remote work, it had mandated the use of the company laptop for work-related tasks. On the date of the final incident, the claimant alleged that she was working remotely, albeit without her company laptop. Consequently, the employer requested the claimant to provide information about the work performed. While the claimant asserted that she worked an 8-hour workday using her personal device, when asked by the employer to furnish adequate proof to substantiate her claim, she was unable to provide the proof of work. She thereafter requested the employer to deduct time that was falsely added by the claimant. Finally, despite the claimant's allegation that she performed work using her personal device, she was aware of the employer's policy which prohibited the use of personal devices for work. Since the preponderance of the evidence established that the claimant mismanaged her time in violation of the employer's work rules, her actions amount to misconduct connected with the work. Reverse the AT decision, misconduct, no chargeback, adequate employer response, and the alternative, I can agree to rehear the case since a reasonable inference can be made that the claimant's violation of the personal device policy was a contributing factor to the discharge. We should rehear the case to review and clarify the employer's personal device use policy. Rehear.
The AT decision is correct. The employer discharged the claimant because they felt that she had misreported time worked on her timesheet. The claimant provided consistent firsthand testimony denying the employer's allegation against her and testified that she was permitted to use her personal phone and mobile device while working from home, and that she had performed her job tasks on the days in question. Since the employer was unable to provide evidence of a specific policy regarding the claimant's use of her personal phone for work-related purposes, and their expectations with respect to the claimant's scope of work, the employer failed to establish that the claimant engaged in any intentional misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Misconduct, no chargeback, adequate response.
Short form dissent, ma'am.
Yes, sir.
Case number 3650165, Commissioner Trevino.
The AT decision is correct. The employer discharged the claimant for allegedly being under the influence of alcohol at work.
May I interrupt? I'm sorry.
Yes,
for that. 3650165. I
Yes, sir.
think we pulled that one. Does it matter what the order of precedence is.
No.
So long as we get a majority vote,
Okay.
the impact on the case will be the same regardless of
Okay,
who
I agree.
votes.
I understand.
I apologize for the error.
You can read it first, Commissioner Esparza.
Thank you for pulling me forward there too. I don't know, man. It's pretty late, man. The AT decision is not supportable. The claimant had reported to work on the final day of employment and appeared to others to be under the influence of alcohol. Third-party testing via breathalyzer showed the substantial blood alcohol percentages. Doesn't matter that the second test administered several hours after the claimant reported to work yielded a result just barely under what the test administrator considered to be a positive result. The first test result was above the limit. In any event, both of the tests occurred several hours after the claimant first reported for work that day. The employer had a zero tolerance policy for being under the influence of alcohol at work, and the evidence shows that the claimant violated that policy. The employer's claim response set forth adequate facts for TWC to investigate the allegation of misconduct. Accordingly, we should reverse the AT decision, misconduct, reimbursing employer not billed. The employer filed an adequate claim response.
The AT decision is correct. The employer discharged the claimant for allegedly being under the influence of alcohol at work. However, the claimant testified under oath that she was not under the influence and that she never drank at work. The employer did not present any evidence that the claimant was put on notice as to the employer's definition of under the influence, and the claimant's breathalyzer results were considered negative by the employer's own testing administrator. Therefore, since the employer presented no direct evidence to establish that the claimant violated their policy, and since claimant's blood alcohol test was negative, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
Misconduct, reimbursing employer not billed, adequate response.
A majority vote is misconduct, reimbursing employer not billed, adequate employer response.
Short form dissent, ma'am.
Yes, sir. And just to clarify as to who may have pulled the case, this case had a more than one recommendation. The most recent recommendation matches the majority vote. So logically, it would have been Commissioner Trevino's pull.
Okay. Well,
But-
thank you for the courtesy anyway, Commissioner.
You're welcome.
The result in the case is the same regardless. So thank you, gentlemen.
Thank you.
Case number 3663155, Commissioner Trevino.
The AT decision is not supportable. The claimant testified that she called in right on time for the AT1 hearing, and commission records show that she registered at 11:46 a.m. for the 11:45 a.m. hearing. Since the claimant made good faith effort to participate in the hearing, the claimant has established good cause for failure to appear at AT1, and the case should be resubmitted for merits testimony from AT2. Modify the AT, claimant established good cause for AT1, resubmit.
We should affirm the AT decision. The claimant did not timely register for the hearing because she misread the notice. Thus, she did not establish good cause for a non-appearance. As to the merits, the available record supports that the conclusion that the claimant quit. In fact-finding statement, she expressed dissatisfaction with aspects of her job, including not getting promoted as quickly as she expected and not being able to work on her own schedule. These reasons for quitting do not constitute good cause to quit. Accordingly, we should affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leave.
Good cause, resubmit.
We will resubmit the case. And that was the last unemployment insurance case pulled on docket 11. You should have received the UI short form dissent list for docket 11.
I move to accept staff recommendations on the remaining UI cases on docket 11.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 11.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in UI short form dissent list for docket 11.
Motion passes with the acceptance noted.
Thank you. Moving on to docket 12.
Case number 3178724, Commissioner Esparza.
The commission should rehear this case. The claimant was terminated for failing to comply with the drug test request. Although both parties attempted to provide information relevant to the final incident, they were oftentimes cut off by the hearing officer when attempted to answer. As such, important information to the case, such as when the claimant was required to report to the testing facility or whether the claimant was requested to make deliveries prior to the test, was not developed. In addition, the claimant's manager, a crucial witness to the final incident, was unavailable for the AT continuance. Since testimony from the employer's witness would be critical to understand the nature of the job separation, we should rehear to clarify the record and to question the employer's witness about the job separation. Rehear.
The decision is not supportable. While the employer discharged the claimant for failing to complete a random drug screening, the claimant provided credible firsthand testimony to establish that he was instructed to make some deliveries before going to the testing facility, and that he still arrived at the testing facility well before the 2-hour window that was given to take the test. But the testing facility failed to perform the test before the window closed. The claimant's testimony was corroborated by 2 other witnesses. The employer only offered inconsistent secondhand testimony to argue that the claimant was at fault for failing to complete the drug screening within the given time. Therefore, the employer failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, no overpayment.
Rehear.
We will rehear the case.
Case number 3634870, Commissioner Esparza.
The employer should be found to have good cause for its non-appearance at AT1. The employer provided testimony that it was unable to attend the hearing due to unforeseen family issues. The employer elaborated in its appeal to the commission that the family issues was connected to illness. The employer should not be faulted for being unwilling to disclose private details about the reason for its non-appearance, especially considering its testimony that establishes the family issues were unforeseen. Since the employer was prevented from attending the hearing due to circumstances beyond its control, we should find that the employer had good cause for its non-appearance and resubmit the case for merits testimony.
The AT decision is correct. The employer testified that it missed the AT1 hearing due to an unforeseeable circumstance. However, the employer refused to provide additional details. The employer failed to prove that they were prevented from participating in the hearing by circumstances beyond their control and did not establish good cause to reopen the case. Regarding the job separation, the employer failed to provide any specific dates or information regarding any final incident which led to the discharge. Therefore, the employer failed to prove that the claimant was discharged for misconduct connected with the work. Affirmed the AT, employer did not establish good cause for AT1, no misconduct.
Good cause, resubmit.
We will resubmit the case.
Case number 3644406, Commissioner Trevino.
The decision should be modified. Regarding the job separation issue, the claimant resigned for health reasons. The employer changed the claimant's schedule and work hours, which affected the health issues he was experiencing. The claimant informed the employer of his medical condition and requested accommodations, but was unable to meet the employer's deadline to provide medical documentation. Though the employer argued that at the rehearing that they would have given the claimant an extension to provide medical documentation, the employer did not inform the claimant that the deadline could be extended. The claimant submitted medical documentation at the rehearing showing that he was seen in the emergency room around the time of the separation, and that in the months following the separation, he was under a doctor's care. Since the claimant left work as a direct result of his medically verified illness, he had good cause connected with the work for quitting. Modify the AT, timely claimant appeal, no voluntary leaving, no chargeback, MVI.
We should modify the AT decision. The commission previously held that the claimant's appeal was timely. Concerning job separation, although the claimant alleged medical concerns for his resignation, he did not provide information to indicate that a doctor advised him to quit. Moreover, the claimant did not request an extension to provide medical documentation nor communicate with the employer nor communicate with the employer about possible accommodation needs prior to quitting. Since the claimant quit without adequately addressing his concern, his separation was voluntary and without good cause connected with the work. As such, we should modify the AT decision, timely claimant appeal, voluntary leaving, no chargeback.
Timely appeal, no voluntary leaving, no chargeback, MVI, and a memo to investigate ability and availability.
You did say, Chairman, I'm sorry, no voluntary leaving?
Pay and protect, MVI.
MVI.
Short form dissent.
Yes, sir.
Case number 3679464, Commissioner Esparza.
We should affirm the AT decision. The claimant was discharged for failing to pass an exam required as a condition of employment. The employer presented two witnesses who testified employees were told at the time of hire and throughout their employment that passing the test was required for continued employment. These same witnesses testified at the appeal hearing for the claimant's coworker and classmate, who was also discharged along with the claimant for failing the test. Given the same issues and largely overlapping witness testimony in both cases, we should take administrative notice of our decision on docket 8 in case number 3687248, where the majority vote was to disqualify the claimant's classmate under almost identical facts. Because the employer has met its burden of providing the claimant was notified at the time of hire that passing the test was a condition of employment, we should affirm the AT decision, misconduct, no chargeback.
The AT decision should be reversed. The claimant was hired as a Scheduler 1 and passed the required exam for that position. The claimant then made 3 attempts to pass the exam to be a Scheduler 2, but was unable to pass the exam and was discharged. The claimant and firsthand witness credibly testified that they were not informed at hire that passing the Scheduler 2 exam was a condition to continue employment. The employer provided no firsthand testimony to refute the claimant's testimony. Since the claimant was not told at the time of hire that he could be terminated if he did not pass the exam, the claimant's inability to pass the exam was an inability to meet the employer's expectations, and the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
I concur with Commissioner Esparza.
Short form dissent, ma'am.
Yes, sir. And that was the last unemployment insurance case pulled for additional discussion on docket 12. You should have received the UI short form dissent list for docket 12.
I move to accept staff recommendations on the remaining UI cases on docket 12.
I second the motion, except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 12.
I concur with the chairman's motion, except for the cases of which I'm dissenting is reflected in UI short form dissent list for docket 12.
Motion passes with the exceptions noted.
Thank you, gentlemen.
Thank you. We'll take a short recess.
Yeah.
Let me ask you something. Have you read Bill that copy that you bought this morning as we learned with copy? Always comes back to me. One thing. Get this off your chest. Yeah, one thing on. It just. Yeah. What else is having as much fun as us? So let's.
Okay.
This is agenda item 9, Texas Veterans Network.
Thanks, Bob.
Morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, Mr. Cerna. For the record, I'm Bob Garrett, Director of the Texas Veterans Leadership Program, Texas with the Workforce Division. In May of 2022, the Commission approved the use of Workforce Opportunity and Innovation Act statewide funds to publish an RFA to build a statewide network of veteran coordinators. The successful respondent, Combined Arms, launched the Texas Veterans Network on 1 April 2023 and continues to provide vital referral services to veterans across the state. These services include assistance with financial and legal matters, participation in career and education programs, connections to veteran benefits and programs, and assistance in meeting basic needs such as food and housing. At its August 20th, 2024 meeting, the Commission approved an exceptional item requesting general revenue funding for the TVN. The exceptional item cited changes to federal funding and requirements may impact the use of WIOA statewide funding for the need to continue the TVN without disruption. The current contract ends on 31 March 2025. Stopping services while awaiting the passage of the General Appropriations Act will have a detrimental effect to services for Texas veterans and could lead to an increase in costs associated with restarting the program at a later date. Staff recommends the use of $425,000 of WIOA statewide funds for a 5-month extension of its contract with Combined Arms for continuation of the Texas Veterans Network. Concludes my presentation. I'm happy to answer any questions you may have.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the use of $425,000 in WIOA statewide funds for a 5-month extension of the TWC contract with Combined Arms for continuation of the Texas Veterans Network as recommended today by staff.
I second.
It's been moved and seconded. Votes unanimous. Thank you.
Thank you.
So agenda item 10, board nominations.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Patricia Martinez, Workforce Development Division. Today for your consideration, we have Workforce Board nominations for Workforce Solutions Capital Area, Deep East Texas, and North Central Texas. Staff recommends approval on the presented nominees, and I'm here to answer any questions that you may have.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the local Workforce Development Board member nominees presented today for the following: Workforce Solutions Capital Area, Deep East Texas, and North Central.
I second.
It's been moved and seconded. Motion carries. I'll see a legislative report. I mean, Bob has a tie on and he's sitting in Michael's chair, but I think we've already heard everything Bob wanted to tell us today. An executive director's report? Or is there any other order of business come before the commission?
Nothing here.
No, sir.
Is there a motion to adjourn?
Chairman, I move to adjourn.
I second.
It's been moved and seconded to adjourn, and we're adjourned.